So I'm making this video as a response to this document that was the closing submissions on behalf of family groups 2 and 3 that was submitted to the Thirlwall Inquiry yesterday. Most of this document is just going over stuff from the prosecution case and the highly flawed Thirlwall Inquiry. Because it's been written by lawyers, it's 173 pages long, and the reason for that is lawyers love just repeating things that have already been established because they think they know that this is a mechanism that's used to strengthen their case. It was used in the court case regarding the conviction of Lucy Letby as well. And also a lot of it is just retreading ground that has been trodden before. However, at the end, they do try to bring forward some kind of original arguments related to the panel of experts, so the evidence that they've presented, which provides compelling evidence that there were no crimes at this hospital. So this video is really a response to that section of the document, which we're going to go through now. Now, I want to be clear before I start that I'm not usually a video maker. I'm not going to do some slick presentation. I'm not going to bring my dog onto camera to try and manipulate your emotions or anything like that. This is just a response to the text itself. So I've written down the text and my responses here, and I'll go through them as we go through the video and explain anything that needs to be explained. So this statement begins by saying the family's submissions are provided with an annex to their written closing in order to reflect that these submissions have been prepared without the input of Mr. Simon Driver. Mr. Driver was junior prosecuting counsel at Letby's trials and during both appeals to the Court of Appeal. If the case is referred back to the Court of Appeal, he will be junior counsel for the Crown at that appeal. So I've simply written, this is an obvious conflict of interest. It is important to note this as the same document accuses the defence of conflict of interest in due course. It's very difficult to see how Simon Driver can be involved in this and involved in the prosecution, and he'll be involved in the appeal, but then claim, oh, it's not a conflict of interest. Obviously, he's been actively involved in steering the families and their perspective. That's undeniable. Whether or not he's been involved in the creation of this document, we have to accept that what they're saying about that is true. There's no doubt that he's had a significant impact on the families, having been centrally involved in the prosecution. So to claim that that's not a conflict of interest is pretty much untenable. The document then goes on to say, I considered that it was important that the family's submissions in this regard should not be taken to represent a preview of any arguments that might be advanced by the Crown in response to any substantive application. To avoid any implication that there might be a crossover in roles or that these submissions were in the form of a statement by the prosecution, I recommended that the submissions be enclosed separately and should not bear his name. For the avoidance of doubt, however, I do not consider that his role in representing families at the inquiry, this is Mr. Driver still, they don't mention his name here, but his means Mr. Driver, in representing families at the inquiry was in any way compromised by his role in other proceedings. As I've written here, this is just essentially waffle. I haven't bolded the section here, I originally bolded it on Reddit, but I'll bold it here. For the avoidance of doubt, however, I do not consider that his role in representing families at the inquiry was in any way compromised by his role in the proceedings. Of course it was. Of course his role in representing the families is compromised by his role in the criminal trial. You know, it's simply impossible to claim otherwise. It's not a view that can be given any credibility whatsoever. So then the next section goes on to state that as things stand at the time of writing, Lucy Letby is a convicted multiple child murderer, the most prolific child murderer in Britain. She has twice brought appeals before the Court of Appeal and on both occasions was unsuccessful. I just said this is waffle and irrelevant. It really doesn't have any relevance to the matter in hand whatsoever. This is just an established fact. I just mentioned briefly, they haven't referenced this quite so much as you've seen in other statements previously, but this idea that she twice brought appeals before the Court of Appeal, this is something you see the Crown Prosecution Service stating. It's not stated quite as explicitly here, but the Crown Prosecution Service will say she's had 2 applications to appeal rejected, or they'll say 2 juries have seen all the evidence. Of course, that's not true because one of those appeals and one of those trials was related to only 1 infant, so it's not true that 2 juries have seen the evidence. So then the document moves on to say, when Sir David Davies urges the Chair, as he does in his letter dated 28th of February 2025, to pause the inquiry, until Ms Letby's avenues of appeal have been fully exhausted, he ignores the fact that those avenues of appeal have already been exhausted. So simply written to that this is a disingenuous argument and irrelevant. No one denies that her previous applications to appeal have been rejected. Her right to appeal in the future could only arise within closely defined circumstances which have so far not been established. Upon the assumption that Letby has abandoned the prospect of making a further direct appeal to the Court of Appeal, her only potential route to referral to the Court of Appeal is through the Criminal Cases Review Commission as established by the Criminal Appeals Act 1995. This is just waffle. This is just telling us stuff we already know. According to press releases, the CCRC received a preliminary application on the day before a press conference held in February 2025 by Letby supporters and chaired by Sir David Davis MP alongside a counsel. The families are concerned that this is not a substantive application, that it was made in order to prevent the media attending the press conference from questioning why no formal appeal application has been lodged, given Mr MacDonald's assurances at a press conference in December 2024 that a direct application to the Court of Appeal along with an application to CCRC were imminent. The families are concerned by the reference to a preliminary application and would ask why no substantive application has been made. This is just waffle. Clearly there will be a substantive application. This paragraph is simply a waste of ink and paper. I should just mention at this point, this is why lawyer documents are always extremely long. So for example, if you look at the Court of Appeal verdict for the original trial, you always get people saying, oh, it's 58 pages long, implying that it's a really deep and profound document, but at least half of the document is just repeating things that we already know, or making these extremely long statements and sentences to just establish things that no one disagrees with. When you actually look at the substance of that document, a relatively small amount of it actually addresses the arguments that are made in any kind of constructive way. A lot of it is just either this kind of waffle or just repeating the prosecution case. With that being said, let's move on to the next paragraph. The reference to a preliminary application to the CCRC appears entirely at odds with Mr MacDonald's announcement at the December 2024 press conference that he would be making an immediate and direct application to the Court of Appeal, that the papers had been prepared and would be sent imminently. Despite this, no such application was made, and in February 2025 he appeared to concede that the only route available to Letby was through the CCRC. The families are concerned that such a bold statement could be made to the press in December 2024, only to have been abandoned by February 2025. It suggests to them that Letby's team are more concerned with publicity stunts than putting forward a proper reasoned or legally sound appeal. How can the families of the inquiry feel reassured that the basis for the application to the CCRC has been made any more carefully reasoned or considered? I'm not sure that makes sense, but never mind. This is important within the context of the former executive's application, as it will offer the chair no reassurance that a properly formulated and reasoned application to CCRC is in existence, let alone that it will be considered imminently. So I've simply said in response to that, this is waffle that has no merit whatsoever. There will be a substantive application imminently. It really isn't the place of these lawyers to critique the way in which an application is submitted. And it just has no merit as an argument whatsoever. It is just nonsense. Irrespective of the progress that Letby may have made with formulating her application, it is axiomatic that an application to the CCRC is not an appeal. So I've written, ignoring the pretentious choice of the word axiomatic, it's clear that the CCRC is a component of the appeal system, given that its sole role is to decide whether or not to refer cases to the Court of Appeal. So the argument made here, the application to the CCRC is not an appeal. No one says that it is an appeal. No one is claiming that it is an appeal. It's a component of the appeal system, clearly. Its job is simply to decide whether or not to refer cases to the Court of Appeal, and the consensus opinion here is that this will be referred to the Court of Appeal, at which point you will be having an appeal. So, this is just an absolutely redundant argument immediately. And the next section states, whilst the CCRC will, within its framework, consider an application and determine whether there are reasonable grounds to refer a case back to the Court of Appeal. According to data published on its website, the CCRC reviewed 31,590 cases between April 1997 and December 2024, referring 855 cases to the appeal courts, resulting in 592 successful appeals. Of the cases accepted by the Court of Appeal, 227 convictions were upheld. It follows that applications to the CCRC are common, but rarely lead to a successful appeal. So, I've just written, it's expected that the CCRC will refer this to the Court of Appeal rapidly, at which point, according to your own figures, 69.2% of appeals are successful. It's notable here that they've tried to use a technique of not mentioning the fact that the majority of appeals are successful once it's referred to the Court of Appeal, and just use this massive figure of 31,590 cases. Now, there's an outside possibility that the CCRC will not refer this to the Court of Appeal, but the general consensus of opinion is that it will definitely be referred. I mean, how is it possible that the opinions of these world-class experts, in some cases, many cases from this panel, the heads of credentialed bodies of paediatrics and neonatology, Professor Nina Modi is the most obvious example, but there are other examples on the panel as well. How can they possibly ignore that when they're critiquing the evidence of, essentially, we'll get into this more as the video goes on, but essentially they're critiquing the evidence of one person who, even one person on the panel, completely outranks Dr. Dewi Evans. That's undeniable again. And there's 14 of them. Obviously, the CCRC is going to have to take this very seriously. Again, it must be emphasised that I would say approximately 25 mainstream publications have now stated that this looks like an unsafe conviction. We've had major people coming out like Joshua Rosenberg to say it looks like an unsafe conviction. I believe Lord MacDonald has now come out and said things. And many, many others, other barristers, other medics, other very credentialed and highly regarded people. So the idea that CCRC is going to ignore this appeal because these lawyers say so is pretty poorly founded. And as is established here, once it's referred to the Court of Appeal, actually most appeals are successful because there's a very high bar to be met. And unfortunately, most people that are in prison don't get a panel of 14 experts coming out and going through the scientific evidence. That's why other cases that we're going to be discussing later in the video take a long time to be resolved, and that's very sad. And in a way, it is unfair that Lucy Letby's case received such a huge amount of attention, while other people that are probably also victims of miscarriage of justice aren't fortunate enough to receive that media attention. All I can say is that for me, this will be a focus of my life for the rest of my life, and if I can do things to help in other areas, I will. I wasn't aware of how poor the legal system was and how many mistakes are made and how many egregious miscarriages of justice take place. So in a way, I feel bad that I focus my energy so much on Lucy Letby, but hopefully it can open the door and lead to a recognition that there needs to be further reform of the criminal justice system. Moving on to the next point, it's stated here, there is no obvious time frame. This really grates with me because it shouldn't be hyphenated, but never mind. There is no obvious time frame attached to the CCRC process or the process that might follow it if the application is successful. This is, in some respects, is a fair comment. I've written here, the comments about the time frame are correct, but this is no reason to ram through conclusions based on an utterly flawed inquiry. It is fair to state that we don't know the time frame associated with the CCRC and then the appeal, but that's you don't say, well, we don't know how long it's going to take, so we'll just these conclusions that are going to impact on the entire healthcare system, we'll just make them anyway. We'll just make the conclusions, we'll make the recommendations based on a flawed inquiry because it's going to take too long to do anything else. It's just a palpably ridiculous argument. So they emphasise it again here. It's unlikely that the process will be dealt with rapidly. I have just emphasised this is a matter of opinion, which seems to overlook the actual situation at the CCRC, which is they've put a special team together to deal with Letby's application, and it seems extremely likely they'll come to a conclusion quickly, and it seems extremely likely that conclusion will be to refer the case to the Court of Appeal. So the next part begins. Sir David Davis's suggestion that the appeal is paused until Miss Letby's avenues of appeal have been fully exhausted and the new evidence has been allowed to be properly tested before a court is woefully open-ended. If the right, hold on a second. It's not woefully open-ended. It's just like typical lawyer speak. It's not woefully open-ended. It's open-ended. I mean the term woefully open-ended doesn't mean it's not woeful. It's simply open-ended. You could say it's regrettably open-ended, perhaps, or you could say inappropriately. It's not woeful. If the inquiry is paused, when would it resume? At the point, if it is ever reached, that Letby concedes that convictions are safe. This argument involves a baseless assumption that convictions are safe. It doesn't matter how many different ways this is argued, there is no justification for the continuation of inquiry when its central premise is likely to be erroneous. Naturally, this will produce erroneous results. That is the entire foundation of requesting Thirlwall to be paused. It seems curious that none of the lawyers are aware of this. Of course, they are aware of it. It just simply, firstly, they're assuming that Letby's appeals will be rejected over and over and over again. While there is precedent to assume this will be the case, it's not a fair assumption because there is considerable substantial evidence now pointing to her innocence and towards this being an unsafe conviction. So to just make this presumption that every appeal is going to be unsuccessful and that this is some sort of illegitimate process is just I'd say it's completely without foundation, but it's certainly poorly founded. And they're just, you cannot argue that, well, we'll just carry on with the inquiry, we'll make some recommendations, we'll implement them over the whole healthcare system, and then 3 years down the line, when we found out that everything we implement was rubbish, we'll just turn back the clock. It's fine for the lawyers because they still get paid, and a year from now they'll be doing something else. So they ultimately don't care. I know obviously they'll say that they care, but their job is to just represent their client. If things had worked out differently, they'd be on the opposite side, or they'd be doing a different case entirely. They could be representing someone who pleaded guilty in court, for example. That happens all the time. So the idea that they're genuinely concerned that the inquiry is completed is just pretty specious, let's say. The inquiry, in contrast, is almost complete. It has heard evidence over several months and the participants have provided closing submissions. The report is intended before the end of the year. There is no obvious purpose in deferring those findings, which have the potential to result in recommendations that encourage a greater focus on patient safety within the NHS. So I've written in response to this that this is possibly the most stupid argument in known human history. Essentially, it is argued here that because the inquiry is almost complete, recommendations which are utterly flawed should be put in place anyway, because this would enhance patient safety in the NHS. And they've said here there's no purpose in deferring those findings. The purpose is that the findings can be completely wrong, and then you then implement that across the healthcare system as a whole. That's a pretty obvious reason to defer them. I've just written here, anyone that needs to have the problems with that assertion explains them needs to seek help. Recommendations have the real potential to save lives. And I've just written in response to that, recommendations that are based on sound evidence have the potential to save lives. Recommendations that are not based on sound evidence have the potential to wreck lives. Of course, particularly in a circumstance, in a situation as important and grave as this, where you're dealing with life or death situations on a daily basis. Then the lawyers have written, they will not realistically be affected by any challenge to Letby's convictions, which have never been considered during the course of the inquiry. This is, again, an utterly farcical statement, as the entire premise of the inquiry has been profoundly impacted by the assumption of Letby's guilt. The assumption of Letby's guilt has steered the entire process, and it has ensured that lots of information and lots of evidence that should have been discussed has never been discussed. In fact, they've quite systematically swept this under the carpet. They've refused to look at their own documents. So just like no one, we know damn well that the inquiry hasn't challenged Letby's convictions because that was established on day one. No one contests that. What we say is that was inappropriate because it's resulted in conclusions that are inadequate and indeed completely flawed. So again, that's just complete sophistry. Frankly, it's utter nonsense as an argument. The families would say that the more probable outcome would be that the forward momentum achieved during the inquiry will be lost, whilst Letby continues to pursue successive unsuccessful attempts to challenge her convictions. I've written here, as this requires the ability to see through time, I'm not sure that it's a particularly well-founded statement. I should also mention with regard to this concept of forward momentum, if you've ever seen the film Thelma and Louise, at the end of that film, they're achieving forward momentum when they drive straight off a cliff. But although that's presented as a heroic thing, I think most people would say that's not really a desirable outcome. Just because there's forward momentum occurring, that's not necessarily a good thing if the forward momentum results in something absolutely terrible happening. So it's like another example from popular culture would be in Terminator. So they're developing the Skynet system and they're achieving forward momentum with that. Once you learn that Skynet is going to destroy the human race, obviously you then want to stop what is going on. You can't say, oh, but this will just disrupt the forward momentum of creating Skynet. It's a nonsense argument. It's a politician's argument. It's a lawyer's argument. It doesn't make any sense. The forward momentum of something that is going to be detrimental should be stopped by definition. If you've got a car going towards something that's going to hit something, you want to stop its forward momentum. You don't say, oh, but pressing the brakes would break the forward momentum of what's being achieved. It's nonsense. It's utter nonsense. The next sentence is, there is nothing in this present application or the evidence in support of it that provides an obvious or realistic challenge to the status quo. So I've written in response to that, it certainly represents an obvious challenge. It is definitely a challenge. This is undeniable. What could be more obvious than that? And then I've written, equally, it's hard to argue that it's not a realistic challenge when approximately 25 mainstream publications have now questioned the safety of this conviction, and countless individuals who are far more credentialed than any of the lawyers have echoed this view. And finally, in this section, they've written, the inquiry is not in a position to review the merits of Letby's grounds for appeal and should not do so. And I've written, as no one has asked them to do this, the relevance of this comment is unclear. So there's a lot more still to come in this video. At this point, I'd just like to apologise for the production values. This is the best I could do in a short period of time. I'm not a video maker, I don't have professional equipment, so there's still a lot more to come, but that's kind of the end of the first section, which is just a load of waffle, basically. Really has absolutely no substance whatsoever. So this next section now starts to deal with something of actual substance. I mean, pretty much everything up until now has been complete waffle. But this section begins by saying the families do, however, have some observations with regard to the evidence that's been adduced in support of the application. The families are concerned by the fact that evidence has been presented on 2 occasions in press conferences, an approach that is entirely unprecedented. I'm not sure that's true, but I'll let that slide. Within the context of an appeal from a criminal conviction, it raises the obvious suspicion that the priority for Letby and her supporters is to generate maximum publicity for a cause rather than approaching the issues that form the basis of any appeal in a reasoned way. I've dealt later with this notion that we are supporters of Letby and that the panel are supporters of Letby and that people that are concerned about this conviction are supporters of Letby, so I'll deal with that later on. In response to this, I've just simply written, the most likely reason for this is simply that the CCRC and appeal system have an abysmal record of responding to appeals. That's not in any way contentious, that's been well documented, there have been lots of mainstream media articles about that. The first instinct of the CCRC and the Court of Appeal is to reject any appeal. Their own statistics make that crystal clear, in fact. This has resulted in several innocent parties having numerous appeals rejected. For example, Andrew Malkinson, who was only exonerated after serving his entire sentence following 3 failed appeals. He served 17 years, I believe. Even cases that predate the CCRC, such as the Birmingham 6, featured appeals being rejected. It's quite significant, that, actually, because the Birmingham 6 is almost celebrated as a success of the appeal system, but they actually served 16 years in prison. And their initial appeal, even after a lot of publicity, after a World in Action TV documentary, after books, after articles, their first appeal was still rejected. So it's important to understand this, that you would think the Birmingham 6 came out of prison quite quickly, but they had virtually 2 decades taken out of their lives, in fact. And then I mentioned here the case of Colin Norris, another nurse whose appeal will finally be heard in May. Despite clear exonerating evidence, his appeal has been delayed, stymied and generally blocked. It is fair to surmise that this is simply due to a lack of public awareness. I would quote the view of Paddy Hill, a member of the Birmingham 6, who sadly died recently. We didn't get our convictions overturned because of the government or the courts. I'll tell you what got our conviction overturned: public outcry. I should add that he made those comments to the BBC in a BBC documentary. I think it was possibly when he was interviewed by a programme called Hard Talk, but it's something that's been cited by the BBC anyway. I've just finally made this comment here that it's understandable that barristers have faith in the legal system. This faith is not necessarily shared by those who don't rely on it for income. And this is something that you see, you will see this later in the document as well. Lawyers always make these procedural arguments, and these arguments from a position of what's sometimes described as jurisprudence, which are just technical arguments related to the legal system. That's because it's the hand that feeds them. So they venerate it to this and put it on this pedestal, which is completely undeserved. And actually, if you look at it objectively, there are polls that indicate that public faith in the legal system is very, very small, actually, and the criminal justice system. So the reason that there's been this press conference and the reason it's been publicised is precisely because there is this appalling record in the past of appeals being rejected. So naturally, Lucy Letby's lawyer, Mark MacDonald, who's been through this numerous times, who's representing people who are in prison, who knows about the Colin Norris case, who obviously knows about the Markison case even though he didn't represent him. He knows that public opinion is going to be critical, just as Paddy Hill of the Birmingham Six has just said. That's why they're seeking publicity. That's why they're seeking the public outcry that Paddy Hill has described. So naturally a lawyer is resistant to that because the lawyer loves the existing system, wants the existing system to continue, wants people to have faith in the existing system, wants the existing system to continue unencumbered. But as I say, that faith in the system is not shared by those who don't rely on it for income, and also by people that have represented innocent people and have tried to get them out of prison. The next point made here is the same concern should apply in respect of how the information provided to the second press conference in February 2025 is being managed and used by Letby supporters. So I will just go through this comment and what I've said here. Firstly, I don't wish to comment on the material related to Child O, as what ultimately matters is the scientific evidence. The contention of the lawyers regarding how people should or should not conduct themselves is completely irrelevant. I personally find such a high-handed and sanctimonious position to be pretty hypocritical, coming from those who will literally argue anything in exchange for payment. This time next year they could be trying to reduce the sentence for a murderer who pleaded guilty, so they would struggle to occupy the moral high ground. It also seems rather unfair to accuse Sir David Davies of being a supporter of Letby. Those that are concerned about this case believe that there has been a deeply unsatisfactory court process which has produced an unsafe conviction and, ultimately, a miscarriage of justice. It is an obvious misrepresentation to suggest that these people are Letby supporters. None of us know Lucy Letby and we have no reason to support her. Describing those concerned about her conviction in these terms is an obvious example of smear tactics, which it certainly is. Point relates to the panel of experts. The panel of experts who form the international expert panel are paediatricians and neonatologists who were tasked to carry out case note reviews of individual cases and determine whether those records disclose alternative causes of death to those presented by the prosecution. Each case was reviewed by two experts, that is to say that the cases were reviewed in silos rather than collectively. So I would assume that this comment about silos is intended to be a criticism of the process, which is frankly ridiculous. It is in fact a strength of this process that the cases were reviewed independently. I'm not sure if suggesting otherwise is being deliberately disingenuous or the lawyers are simply ignorant, or it could be both. It's considerably preferable for cases to be reviewed in this way rather than have one long since retired paediatrician, Dr. Dowie Evans, prepare multiple reports. And I've written here as a note that he kept changing his conclusions, doing this numerous times for certain cases, even after the trial had been concluded. Then his reports and conclusions were handed to Dr. Sandy Bohin, who essentially rubber stamped them, and then very late in the day other experts engaged in a very limited discussion. It's also notable that several other experts who were cited in court, often they didn't even appear in court, offered either no or very little explicit support for the prosecution case. It is indeed an incredible misrepresentation of the prosecution case to present this as a group effort, leaving aside the problems that are inherent in this anyway. There was no blind peer review in the prosecution case, no one contests this, yet it is almost universally agreed that peer review should be blind. This is precisely why Mark MacDonald has requested for the neonatal experts to conduct the research independently. Attempting to cite this as a weakness of the process, while elevating the prosecution case as some sort of group effort, is again either stupid, ignorant, or both. I think it's a really critical point because they go on to make this argument about you need to see the totality of cases, you need to see the bigger picture. And it's constant the argument is being made that, you need to understand the context, but that's not they contradict that later in the statement. But the critically important thing to understand is that what Mark MacDonald has done is run what you might describe as a conscientious scientific procedure. That is not what happened. Surprisingly, Cheshire Police were not able to do that with Dr. Evans, and they didn't do that. And it should never have taken the length of time that it did. The fact that it took 5 years is not a strength. It's not a strength of the process, it's a weakness. Because they should have been able to draw conclusions and definitive conclusions far more quickly. The fact that he's changed his opinion, not slightly, but he's radically changed his opinion numerous times. And he is the absolute foundation, Dr. Evans, of this process that is being described here. So, I mean, this comment that they've made here initially about working in silos, blah, 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 is just a comment that's completely without merit. I mean, I hope the lawyers know that it's a comment without merit. but there's a possibility that they don't, and they genuinely think it's a legitimate argument. It's very hard to say. So let's move on to the next one. It is unclear what information was provided to the experts, save that they saw medical records and witness statements. From the summary, it appears that witness statements means expert witness statements, although, again, this is not entirely clear as only a summary report has been produced. I mean, essentially, this sentence is just the lawyer having an argument with himself. In any event, it is not suggested that the panel saw transcripts of the evidence given at trial, that they necessarily saw all of the expert reports provided at trial, or that they saw other evidence, such as the witness statements provided by other witnesses, or read transcripts of their evidence given at trial. So I've simply said in response to this that I'm unsure of the relevance of this. The expert panel were asked to review the medical evidence relied on in court, which is what they have done. It's hard to imagine what else you would expect them to do, really. Firstly, in looking at cases in isolation, this is where they bring in the silo argument. Firstly, in looking at cases in isolation, the experts are vulnerable to the suggestion that they miss the bigger picture. Oh, it's the bigger picture. It's the Lucy's always present picture that we must pay attention to. Or the evidence that could be drawn from one case might influence their interpretation of another, which shouldn't happen. I mean, I'm going to argue this in a second, but that simply just should not happen. The fact that Child O, for example, had a brother who died in suspicious circumstances 24 hours after him. Similarly, that Child A and Child F, also referred to by the panel, had siblings who collapsed or died within a short time before or after them, or that it might appear increasingly less plausible that the neonatal unit, and Letby in particular, would be plagued by a succession of events that would, if they occurred individually, appear inherently unlikely. I mean, there are so many problems with this statement. I mean, I haven't actually addressed it in full, because it's just impossible. It would be that could be a half-an-hour video in itself. The families would think it obvious that when trying to consider evidence as a jury might have done, it is important to look at that evidence as a whole, not in silos. Now, again, I mean, I've said that this is a lawyer's statement. I find it incredibly unlikely that this was an argument put forward by the bereaved families. This is an obvious lawyer's argument, and so much of this document is just lawyers' arguments that's come from lawyers. So I don't think we should necessarily see it as representing the families. It really is representing the lawyers that are representing the families. And I think that's a very important point that we need to be clear on. As there is nothing in the panel's report to suggest that children A, F and O had conditions that would also have harmed their siblings, why did their siblings collapse or die in quick succession following interactions with Letby? Another collection of unfortunate coincidences? I mean, this is literally asinine. But I have written a response to it. A much longer response would be possible, of course. But I've simply said there are so many poorly founded arguments here, I'm not sure that they can be addressed in full. This paragraph is reliant on Lucy Letby always being present. Even if this is true, which it isn't, this doesn't have any merit if none of the children died due to inflicted harm. In any medical review, the only feasible approach is to examine the circumstances of each individual infant. Indeed, regardless of the merit or otherwise of Dr. Evans, this is exactly what he did, as evidenced by the fact that he eliminated 11 of the 18 deaths on the unit from the court case. According to this argument, he was wrong to do so. He should have looked at the bigger picture and lumped them into the court case as well. The problem with doing this is that it would have shattered the prosecution case immediately because it wouldn't have been possible to place Lucy Letby on duty. The paragraph also talks about plausibility. It doesn't matter whether or not something is plausible when you have medical data which points to actual real-world explanations. This is another brain-dead argument from people who don't understand probability. Improbable and statistically unlikely things can and do happen. Nearly every week there is at least one winning lottery ticket. Many planes do not crash, but sometimes one plane does crash. Many infants survive, but some infants do not survive. When dealing with a case such as this, you don't examine what is plausible, you examine what actually happened. In answer to the question of whether this was all a coincidence, firstly it should be stated that it could be. Coincidences do occur. Usually, in fact, conspiracies are dismissed in favour of coincidences. However, to quote prosecution barrister Nick Johnson, we know that in this extraordinary case that context is key. We know this was a failing hospital that was downgraded. We know they were understaffed and underskilled. We know that there were unsanitary conditions. We know that the health of the infants was very different to how it was portrayed in the court case. In that context, these coincidences become far more plausible. So I don't really think that requires any particular explanation. It's just an extremely poor argument that relies on this coincidence theory that's been advanced in court that we now know has no foundation because of the Unheard article, which I'll show you that article in a second. So this is the Unheard article by journalist David Rose. He's written another article since then. where he looks at the statistical chart that appeared in court and points out that Lucy Letby wasn't on duty for several of the collapses. And we also know that the source of this was a rota chart of Lucy Letby herself that was provided by Dr. Dowie Evans himself to Peter Elston. So that this idea that, Lucy's always on duty, that is being relied on by this statement is completely debunked by this article. So that can just be put to bed immediately. So at this point, the document starts to get a bit surreal. And one of the things that always interests me about these legal documents is, and I think generally legal cases as a whole, is that lawyers never seem concerned about completely contradicting their own arguments and their own cases. So here we see them say, secondly, case net reviews, as Dr. Horden agreed, are by their nature superficial in approach. I could have written a very long response to this, but I've just said we should be clear at this point that the prosecution case is entirely based on a case note review, which one of the prosecution lawyers has now described as superficial. Of course, it was worse. It was significantly worse than Dr. Horden's review. It's significantly worse than the review that the panel of experts is now engaged in. But here, when it suits the lawyers to say, oh, it's superficial, then they assert this, but they just completely ignore the fact that Lucy Letby has been convicted on a case note review. She's been entirely convicted on a case note review, which is superficial. But of course, when they need to rely on that case note review, they'll say, oh, this is the highest quality of medical evidence. Moving on. When considering the case of Child E, for example, the medical records provide a misleading account of events because Letby altered them. So I said in response to that, this was an allegation made by the prosecution in court which is unproven. In fact, no evidence of any substance was provided for it. Further examination has revealed that the assertions this paragraph goes on to make are extremely poorly founded and certainly not established. I just wanted to say with regard to that in court, what occurred was the prosecution would cite various things that were entered in the datix, which is like the record that nurses fill in, and doctors as well, in NHS establishments. I don't know if it happens in the private healthcare system. And they would say, oh, look what's entered on the datix. This proves our case. But then on other occasions, when it contradicted their case, they would just say, oh, Lucy Letby made that up. Even though they had literally no evidence to point to that whatsoever. They did the same thing with swipe card data. They used swipe card data and then on other occasions said, oh, well, that doesn't mean anything because you could have just sneaked in behind someone. Which is the whole reason the swipe card, one of the many reasons the swipe card data is worthless. So it was, in this case, there was some eyewitness account or recollection given in relation to some event that supposedly occurred at a certain time, but it seems likely that the parents' recollection is simply wrong. However, I mean, this is just, they're talking about this as if it's an actual fact, when it's just simply an assertion made by the prosecution, a flawed assertion, a highly flawed assertion made by the prosecution. In their analysis of baby 7, child G, the panel failed to mention that there was a very large projectile vomit crossing several feet away from child G's cot, evidenced in the medical records, but explained more fully within the evidence given at trial. The volume of that vomit, combined with the volume of gas and fluid that was removed from child G's stomach by the treating doctors, far exceeded the small amount of expressed breast milk that she had received. This formed part of the prosecution's case against Letby, but it's not analysed by the panel. Now, I've explained here briefly why it's not analysed by the panel. The reason this wasn't analysed by the panel is that the assertions made in relation to the overfeeding of child G have no merit whatsoever. I would be amazed if even one person with any relevant qualifications and or experience will offer any support for this, but if there is one, then there will be 10 times the number that consider the opinion of Dr. Evans and Dr. Bohin to be ridiculous. I'm going to mention a few specific things as well while we're here. So they're talking about this projectile vomit. What they don't mention is this happened numerous times. There were several projectile vomits, not just at the one collapse that they've cited as being particularly important in this case. This whole thing about the volume of vomit, blah, 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 is reliant on a ridiculous estimation. And simply the reason this has been given no credence is because it has no credibility.
has zero credibility as a medical explanation for the collapse of the extremely premature child G, who was born after 23 weeks, I believe. It just is a joke, frankly. It should never have been in a court case, and that's why the panel of paediatricians and neonatal experts have completely rejected it. There's simply no need for them to look at it, because they know that it has no credibility, because they've given far more feasible explanations for what occurred. That's why they didn't analyse it. So, I hope that's clear. So I'll mention at this stage, I wasn't necessarily going to mention this, but I will mention at this stage that I've been writing a book on the Lucy Letby case that will be coming out later this year. And I've interviewed many medical professionals of various types, and I couldn't find one who thought there was any even possibility that this diagnosis was correct. And as I say, I would really challenge people to try to find any healthcare expert who says that what Dr. Evans said about this child in court has any credibility, and I think you'll struggle to find anyone. Of course, it should be emphasised as well that no experts come out in favour of the prosecution case whatsoever, but this particular element of it is just utterly ridiculous. That's why the panel hasn't analysed it. So the next point on child G is that events that unfolded hours or days after this precipitating event are truncated so that they all appear to be occurring simultaneously. Rather than being critically unwell at the time of her vomit, child G was doing well. She deteriorated and became severely unwell after she was attacked. I'm not going to go into any great depth on this, but again, this is not really a fact, it's simply repeating the prosecution case. The point is that highly flawed medical evidence was presented in court, and the case of child G was emblematic of this. What you could simply say is that this is untrue. It's a complete misrepresentation of what we know about child G and her circumstance and the circumstance of the child. So I'm not aware if it's... Oh, it is a she, yes. I didn't want to say she if it's a he, but yeah, it is a she. So yeah, it doesn't accurately represent the circumstance of the child. So the next point, it moves on to child I. In the analysis of baby 9 child I, the panel postulate the colonisation of an endotracheal tube with Strenototrophomonas maltophilia, I believe that's correct, caused thick secretions to block the ETT and interfere with ventilation, causing recurrent episodes of apnea, desaturation, bradycardia, respiratory failure and collapse. S. maltophilia colonisation would have further compromised her ventilatory capacity. The summary report omits to explain that child I was never treated for S. maltophilia because testing never revealed evidence that child I developed an infection due to S. maltophilia. Now, the first thing to note here is that this is the summary report, so we don't even know what's in the final report, so that can invalidate this point immediately, which is what I've written here. As the full report is yet to be released, this paragraph can be viewed as pure sophistry and speculation. I don't even think this point is relevant. I think it's really something that has no medical credibility whatsoever. You would need to have a more qualified person than me analyse this in more depth, but I would suggest that this is just a completely bogus argument. So move on to the next one. The panel also failed to recognise that whilst child I was ventilated using an ETT, endotracheal tube, during the early part of their life, they were not ventilated and did not have an ETT in place at the point when Letby caused their death, and had not been so for some time. So I've written in response to this, the lawyers, who incidentally don't have the slightest idea what they're talking about, failed to recognise the fact that an ETT tube was not in place at the point when Letby allegedly caused her death, which is not established, can be completely irrelevant for numerous reasons, not least that it's not proven medically that this period was significant. The period that is actually significant does not need to be that which was asserted by the prosecution if this is based on erroneous information, which seems highly likely. Instead, an earlier period, as cited by the panel, can be ultimately responsible for the collapse of this infant. I mean, again, this is almost certainly just a completely bogus argument. I mean, even I was able to understand why it was flawed. So God knows what paediatricians and neonatologists would make of it. But the point is that they're saying, oh, this period that's been identified by Dr. Evans is sacrosanct, but in actual fact, that's complete rubbish. The whole point is that they found different explanations, so that period then doesn't need to be elevated to this great significance. It may be of no significance or no particular significance. The families are concerned by that's it. That's the specific information for now. So we move on. There is more later on, to be fair. The families are concerned by the range of experts who formed the panel. Although 14 experts are put forward, they are all neonatologists or paediatricians with one specialist in infectious diseases. So I have written here, this is rather foolish. It is an obvious strength of the panel that is comprised of neonatologists and paediatricians, although it is not entirely comprised of such experts as others were involved as well. I should have mentioned really that there's a panel of over 50 people, so they have multidiscipline people from a wide variety of fields. Naturally, when examining the records of neonates, very highly credentialed and active neonatologists and paediatricians are the obvious choice for the job. Bear in mind that when the same task was conducted by the prosecution, one retired paediatrician who was nowhere near the ranking of even one of these 14 experts did virtually the whole job by himself before he then handed the report's conclusions to Dr. Bohin for a deeply inappropriate and unsatisfactory peer review. The fact that none of the other experts can even meaningfully contribute to this is not contested, even by the prosecution itself. There is no conceivable way that anyone can legitimately elevate the process of the prosecution above that of this panel. This is why there are so many mainstream publications and respected individuals now speaking out about this case, while there has been literally no serious person with any credibility or credentials who has openly supported the prosecution case. That doesn't really need any further analysis. It's pretty much undeniable. None of the experts appear to possess any forensic experience. The very basis of the prosecution case was overruling a pathologist, so that a retired paediatrician with no forensic experience, who hadn't even worked in a hospital for over a decade, could perform a case note review, which you yourselves have described as superficial. I don't necessarily agree with the assessment of this being superficial, as it is hard to know what else could be done other than a case note review once you've overruled the pathologist and also the medic who then reviewed the pathology reports. Again, this is pretty self-explanatory. The evidence presented by the prosecution at trial was, as one would expect, multidisciplinary. I've already addressed this previously. To characterise the process as multidisciplinary is completely lacking in merit as a claim. 95% of the prosecution case is Dr. Evans, and that's a conservative estimate. The other experts provided minimal support for his hypotheses and sometimes disagreed with him in court. Again, that's fairly self-explanatory. I would just say that they're obviously trying to elevate the prosecution case above the expert panel, whereas anyone that knows anything about medical matters, and indeed anyone that's even remotely objective, completely disagrees with this. I mean, it really is an untenable position to take. The evidence presented by the prosecution at trial was, as one would expect, multidisciplinary. Taking Child O, for example, the chair can see from the Court of Appeal's analysis of the expert evidence that the prosecution adduced evidence from multiple expert witnesses of different disciplines. Dr. Marnaridis, paediatric pathologist, who gave evidence to the effect that Child O's liver injury was the sort that one would only see in serious accidents, such as a road traffic accident, that it was inconsistent with CPR. I should just briefly mention that if you're going to elevate the view of a paediatric pathologist, you could have just got the original pathologist's opinions, because they actually examined the infants. Of course, Dr. Marnaridis did not. So I've said in response to this, the first thing to mention about Child O is that Dr. Evans walked into a police station and concluded that this case involved inflicted harm within 10 minutes, according to his own account. This is a fairly extraordinary admission. It is notable that Dr. Marnaridis was also the strongest supporter of the Dr. Evans theory that Letby had injected air into the stomach of infants, who was since written to Channel 5 retracting this theory. I think I'll just pause at this moment to show that letter. So this is the letter that Dr. Evans wrote to Channel 5. And the particularly relevant section to what I was just saying is here, which says, none of the babies were killed as a direct result of the injection of air or fluid in air deliberately injected into their stomachs, which firstly is contradicted by what was stated in court, and secondly, I think Marnaridis is not going to be too happy with that, considering that he supported this in court quite explicitly. So now Dr. Evans has withdrawn that, and this is one of the contentions of the defence in terms of fresh evidence as we know now. So I just thought I'd put that up on screen so people can see it if they haven't seen it before. Yeah, so to return to the document, as we've seen, there's a big problem with Dr. Marnaridis and Dr. Evans. So it's fair to state here, it's suspected that his final reports, these are the reports of Dr. Evans, have also changed the methods of inflicted harm for several infants in the case. So there are only really two possibilities. Either Dr. Evans has lied to Channel 5 or Dr. Evans has changed his final reports. We know for a fact that he's made statements previously to The Guardian and other media outlets indicating that he changed his mind, but but then he's denied that he's changed his mind as well. So he's a very strange character. He's pretty much the opposite of what you'd expect from an expert witness. You'd expect this really authoritative person that is extremely professional, and he just seems to run completely contrary to that. It's very weird that he's managed to get into so many court cases, but again, this just shows you, I think, some of the weaknesses rather of the criminal justice and judicial system. Moving on to my next comment, fully responding to the specifics of this paragraph would require me to quote something that is hundreds of words long, which is only an abbreviated version of a much longer document. Suffice to say that the criticisms here have already been fully addressed, even by the preview document and public statements related to it. So I'm not going to go through that. As I say, there is a full review that is, according to Thirlwall, is going to be submitted this week or by the end of this week. That is literally, if you go over all of the infants collectively, it's going to be hundreds of thousands of words and tens of thousands of words for each infant. So this rather flippant paragraph is not really going to have any merit whatsoever next to that. There are already explanations out there that respond to this in the preview documents, but I'm not going to go over them here because I'm going to go over some more of the details later on. Professor Arthur's radiologist, who reviewed post-mortem x-rays and noted that there was air in the lungs and the great blood vessels. This was, in his view, unusual, which would sometimes be seen in cases of necrotizing enterocolitis, not present, or after severe trauma. It was consistent with air embolus. Now, I've just written here, Professor Arthur has never offered explicit support for the hypothesis of air embolism at any stage during the trial, which is true, and was not involved with the creation of this theory, which is also true. It's notable here that this paragraph says it was consistent with air embolus, which is exactly what was said in court by Professor Arthurs. Now, any medic will tell you that being consistent with something is not diagnostic of something. It's a critical difference between the two. Just because something is consistent with something, it doesn't mean that it's diagnostic. So, to give you a slightly crass example, if someone threw up all of a sudden, you couldn't say, oh, you've obviously got air sickness because you're not in an aeroplane. But being sick is consistent with air sickness and being sick in an aeroplane. So it's not diagnostic of that, obviously. Obviously, this is a rather more complicated situation, but I'm just going to show you something to demonstrate this further. So we're going to ask a question to ChatGPT in accordance with what I've just been discussing that I've prepared here. It's simply, in medicine, does being consistent with mean being diagnostic? So hopefully it'll work. Yes, it's actually working. Not necessarily. In medicine, being consistent with means that a particular finding, symptom or test result supports or is compatible with a certain diagnosis, but it does not confirm it. On the other hand, being diagnostic of means that a finding is specific enough to establish a diagnosis with a high degree of certainty. For example, the imaging findings are consistent with pneumonia, the findings suggest pneumonia, but other conditions might still be possible. The presence of Reed-Sternberg cells is diagnostic of Hodgkin's lymphoma. This finding confirms Hodgkin lymphoma because it is a defining characteristic of the disease. So something consistent with a disease may suggest it, but further testing or clinical correlation is usually needed for a definitive diagnosis. And that is precisely why, in the court case, Professor Arthurs was very careful about saying that the air was consistent with air embolism, but is not diagnostic of that condition. And in fact, he offered very little support for the prosecution case, if any at all. It's very important to understand that because in the assertion is being made that Professor Arthurs was significant, but he actually wasn't significant in the diagnosis made by Dr. Evans. And it was a fundamental issue throughout the court case was that Dr. Evans used things that were consistent with a certain condition or could be said to be consistent with it. In some cases, he cited things that weren't even consistent with the condition, but then he treated these consistent things as being diagnostic when they certainly were not. Professor Arthurs did not do that. He said that these findings related to air were consistent with air embolism but not diagnostic of it. And Actually, he also provided studies that suggest that gas is present in many infants, which we knew to be the case anyway. This is all stuff that medics know. I mean, how this ever got in a court case and how it was ever used to convict someone for 15 life sentences, I've absolutely no idea. But I just wanted to demonstrate this in an illustrative way. So to return to this document, the lawyers go on to say, Dr. Dowie Evans, paediatrician, who felt that Child O's collapse was consistent with air embolus and severe trauma to his liver, of course, as this expression was consistent with again. He noted that transient skin discoloration was consistent with air embolus. So I'm saying in response to this, we now know beyond all doubt that he was wrong about the discoloration, as we also know he misused the paper of Lee and Tanswell as a sole diagnostic source for this, and now the author of that paper said quite explicitly that he was wrong. As far as I'm aware, no one disputes that this infant suffered liver damage. What is contested is how this occurred. It is bizarre that an air embolism was seen as significant in this case when Letby supposedly inflicted deliberate harm on the child's liver. I don't think there's too much to add to that. It's just some very strange things were said in court. I don't want to go through everything the panel has said. The purpose of this video is not to go through that because they're going to get a 30,000 words review of the infant, so I don't have access to that. The public statements are out already of the panel. They're already in the public domain. I don't think there's anything to be gained from me going over them all, but all these things have already been responded to publicly anyway. Dr. Sandy Bowen, neonatologist, who concluded that the collapse had been caused by air embolus based on a constellation of factors, including the transient skin discoloration and the finding of air in the great vessels, she did not accept that it was plausible that the liver damage was caused during resuscitation. Essentially, this is just repeating the prosecution case. The whole point is that far more qualified people have found different explanations for what occurred, and these conclusions were arrived at by a more appropriate process, which is undeniable. There is no reference to Professor Arthur's findings of gas in blood vessels on X-ray. As I've just explained this, but the reason that it's not referenced in the preview report, it may be referenced in the final report, is that it's not relevant. Again, it's important to emphasise that it's not diagnostic, it's merely a finding of gas. It can be there accidentally, it doesn't have to be there due to the direct injection of air. And in fact, in the overwhelming majority of cases, it's not there due to the direct injection of air. And also we now know from Professor Arthur's evidence that gas and air is present in many, many infants. So really, that's just another kind of medically illiterate point, I suppose. Indeed, the panel do not contain any experts qualified to comment on the analysis of post-mortem x-rays. And I just said the panel do not consider this significant, and even Professor Arthur never asserted that an infant died due to embolism, which is true. The statement that blunt direct force trauma to the right abdomen or chest is implausible because it is very difficult to generate the kind of forces required to produce the observed injuries in a liver protected by a lower chest wall disregards the fact that a paediatric pathologist experienced and examined traumatic injuries gave evidence to the contrary. So I've simply said other explanations have been given for these injuries. It is important to note that in normal circumstances no one would jump to the conclusion that an unusual liver injury was caused by inflicted harm, which is in itself a hypothesis. This assertion is reliant on the argument used earlier, which is that there were so many cases that it's too much of a coincidence for them not to be caused by one person. However, we know now that many of the other cases are based on extremely poorly founded medical evidence, and therefore the likelihood of inflicted harm is extremely low. In the case of Child O, therefore, it would be usual not to assume that inflicted harm had occurred. Even before the panel had convened, numerous experts had cited a subcapsular hematoma as significant in this case. For example, Private Eye has cited more than one expert that had drawn this conclusion, and this has now been confirmed with further evidence provided regarding liver damage. It is simply far more likely that this has occurred than a hitherto highly regarded nurse attacked an infant for no reason and with no motive. So that's all quite clear, but I'm just going to show you now this reference to subcapsular hematoma in Private Eye. So this is Private Eye, the excellent work of Dr. Philip Hammond. This was the fourth article of the 17 that he's now written on the Lucy Letby case, and in this paragraph we see here what the jury should also have heard. A plausible alternative for the clinical picture and liver damage from experts who acknowledge the clinical records is a ruptured subcapsular hematoma of the liver, possibly compounded by resuscitation injury. These are well-known and well-referenced causes that should have been explained to the jury but weren't. I'll just go on to Private Eye 6 as well. So there's a bit more here in the 6th edition. I'll just draw your attention to. A possible answer came later in the Tortoise podcast, Lucy Letby, the expert witness, in which a neonatal pathologist looked at the notes blind. Looked at the notes blind. Is that understood? Obviously it wasn't understood by the lawyers or by Dr. Evans or by Dr. Bohin, and determined it was more likely a subcapsular hematoma. This is rare but recognised and more likely after difficult premature multiple births. So the only thing to add to that is that both of these articles were written before the panel convened, or before Dr. Hammond even knew that there was going to be a panel. So the panel has now come to the same conclusion. What does that tell you? So to return to the document, the next statement made by the lawyers is, it is notable that the panel does not include an obstetrician who one would expect to be better placed to comment on the types of injuries that might plausibly be sustained during a caesarean section. In response to that, I've written, I presume that you have consulted with an obstetrician before making this statement. The panel can obviously consult with other people and indeed review published literature. Remember that large swathes of the prosecution case are based entirely on one published paper, and the author of that paper is now defending the woman who was prosecuted on this evidence. So it's just a typical lawyer attempt to muddy the waters, but it really has no merit again. These are absolutely world-class experts who have drawn together their expertise and their knowledge in analysing these cases. And the idea that some half-arsed lawyers and maybe people posting online that are contributing to this, as it would appear, are somehow going to outwit these people that are, as I say, they're heads of major paediatric and neonatology bodies. And I think to make these kind of sort of nitpicking observations that don't really actually provide anything of substance is pretty transparent, really. So then the next comment is, the families would therefore say that whilst the number of expert field is impressive, their experience and expertise is not sufficiently diverse to cover the issues that are being explored. So I've written in response to that it is clear that the expertise of the panel far outranks those involved with the prosecution, particularly as most of the prosecution case was based on the work of a retired paediatrician. Dr. Evans, inappropriately I might add, then appeared in court as an expert witness, and those of us who have read the court transcripts know that his performance was far from impartial and at times utterly bizarre. In addition, the lawyers here have acknowledged that the panel is impressive, and I think they know that it far outranks the prosecution, yet they refuse to acknowledge that the panel could have made a valid argument or diagnosis at some point. This in itself immediately discredits virtually everything that lawyers have to say about the panel. It's clear that they're not being even remotely objective. It's actually surprising that they said that the panel was impressive. I suppose they really have no choice other than to acknowledge that, but they should have. I'm surprised they didn't gloss over that, to be honest. It wouldn't change the material reality that everyone knows that the panel is impressive, but I'm surprised they made that concession, because the same really cannot be said for the experts that appeared in court, because I will actually take the time now to go through them. I'll show you who appeared in court and what they did so that we can compare the two. So here we have on the screen the expert witnesses that appeared in court. So the first thing to say is that Dr. Simon Kenny made literally zero material contribution to this case. It's almost impossible to find out what he did, but it is actually possible. With a lot of digging, he did provide a statement, but it just offered no material support to the prosecution case whatsoever. He was brought in to comment on one very, very minor issue. So Dr. Simon Kenny is gone immediately. You even struggle to find any reference to him, even in court reporting or anything, because he did basically nothing. Similarly, Stavros Stivaros, apart from being lumbered with a rather unfortunate name, he just wrote, again, submit a statement which said the imaging can only describe the brain damage resultant from this episode. It cannot determine the underlying cause of the collapse, about which I defer to clinical opinion. He's gone. He offered no contribution, no support to the prosecution case whatsoever. We've already discussed Professor Owen Arthurs. he offered no support of the prosecution case whatsoever. So now we're on to Professor Hindmarsh. Now this was an insulin expert who stated in court that it potentially could have been added to feeding bags. But he also agreed with Ben Myers that there could have been other possible explanations for the readings recorded. So I would suggest that he essentially offered no support to the prosecution case. So you're left with these four people. Now, I'm going to be generous to the prosecution and say that both Sally Kinsey and Marta Rides offered support to the prosecution. We're going to discuss Sally Kinsey later in this video. We've discussed Marta Rides already. But really, they were not, neither Kinsey nor Marta Rides were big figures in this court case. They appeared in a pretty limited capacity, and Professor Sally Kinsey made concessions related to air embolism that run contrary to the prosecution case. Marta Rides now finds himself in the embarrassing position of having supported something that Dr. Evans has written to Channel 5 saying that he doesn't believe, although he said it in court. So that's what you're left with. And it should be emphasised that 95% is these two. It's Dr. Evans coming up with the theories with the police, and then Dr. Bohin having the theories handed to her and her rubber stamping them. That's exactly what has occurred. Up against them are these people. So it begins with Professor Jeff Chase, one of the world's foremost experts on the effects of insulin on preterm babies. Professor Joanne Langley, head of Division of Paediatric Infectious Diseases at Dalhousie University. Dr. Helmut Hummler, Senior Medical Director at the European Foundation for Care of Newborn Infants. Professor Mikael Norman, resident at the Karolinska Institute in Sweden and founder of the International Society of Evidence-Based Neonatology. Professor Eric Skarsgård, resident at the University of British Columbia and director of the Canadian Paediatric Surgery Network. Dr. Tetsuya Izayama, head of Division of Neonatology at Tokyo's National Centre for Child Health and Development. Nalini Singhai, Professor Emeritus at the University of Calgary and co-editor of the World Health Organization Helping Babies Survive programmes. And finally, Professor Nina Modi, past president of the British Medical Association, UK Medical Women's Federation and UK Royal College of Paediatrics and Child Health. Professor Modi has held by election the three leading national children's research positions in the UK, President of the Neonatal Society, President of the Academic Paediatrics Association of Great Britain and Ireland, and Royal College of Paediatrics and Child Health Vice President for Science and Research. Bear in mind, that is half of the panel, firstly, and secondly, I haven't included Dr. Xu Li in that list. So we've got those people up against those people, and it's mostly this one and this one. Yeah, this guy is a pathologist, and he did offer some support for the prosecution case. Professor Sally Kinsey's support really was extremely limited. And then they're up against this panel, and that's only half of the panel. That's not even the full magnitude of, if the court case began tomorrow, that's what they'd be up against, except there's countless other experts as well. There's the other half of the panel. There's over these over 50 experts from we haven't even discussed the statistics really in this video. There's numerous statisticians involved that have already torpedoed the prosecution case completely. So we're returning to the document now. I'm going to try and get through the remainder as quickly as I can, because I'd like to keep this video under 2 hours. I don't know if that'll be possible, we'll see. So as I say, there's some comments about the panel and it being impressive. That's an understatement. The families are concerned that amongst the panel was Professor Nina Modi. So we've just seen the credentials of Professor Nina Modi, who was president of the RCPCH at the time that it conducted its own review of the COCH in 2016. The inquiry has heard evidence regarding this review and will note that the RCPCH apologised through its representatives and witnesses for its own failures in that review. I mean, essentially, it was put under massive pressure to do this. It's citing that essentially these lawyers were the people that put the RCPCH under pressure to apologise, and then they're citing that as being significant. But anyway, the families consider that Professor Modi's role as president of the RCPCH creates a conflict of interest. They would observe that it is highly unlikely that she would be accepted as an expert on issues relating to Letby in civil or criminal proceedings due to this conflict. I find that an extraordinary statement and frankly utterly ridiculous. It is firstly rather unfair to call into question the objectivity of Professor Modi, particularly given her credentials, Professor Modi is one of the most respected neonatologists in the country, as well as being past president of many esteemed organisations. I will note that this statement has not implemented the same exacting standards when assessing, for example, the contribution of a prosecution witness whose previous evidence in court was described as worthless by a judge, with this judge having written to the trial judge in the Letby case to inform him of this. Of course, we're talking about Dr. Evans there. Could this possibly be because one of the lawyers who prepared this statement also worked for the prosecution? Obviously not, because it has already been explained to us that there is no conflict of interest here. I would suggest that this is the definition of someone living in a glass house and liberally tossing stones around. The RCPCH review is the most thorough and authoritative review of the circumstances at the hospital that has been conducted, and it found no evidence of wrongdoing. Now a panel of experts that far outranks the prosecution has also found no evidence of wrongdoing. To gloss over this and suggest that Professor Modi, one of the most highly regarded medics in the UK, is somehow biased, whereas gun-for-hire Dr. Evans, who has never lost a case according to his own post-trial bragging, is somehow completely objective, is somewhat fanciful. It should also be noted that citing material heard by the inquiry as possessing evidential value is flawed in itself, as the entire remit of the inquiry was predetermined from day one. Thus, the inquiry has ignored a multitude of its own documents and has drawn conclusions which are, in various degrees, fallacious, specious and stultifyingly misinformed. This is indeed the entire basis and rationale for pausing the inquiry. Of course, by the time this video is released, it will be clear that the inquiry has not been paused, so now we're in the very dangerous situation of them drawing recommendations from erroneous information, and that being then polluting the entire healthcare system, which is very worrying for people working in the healthcare system. I don't think it will necessarily impact on Lucy Letby's appeal and CCRC process, but it should be considered very concerning for anyone that cares about the NHS and cares about the healthcare system, which should be basically everyone in the country, I would think. Then they say Professor Modi, this is referring to, is curiously the only UK-based expert on the panel. Firstly, I mean, this isn't curious. The reasons for this are well documented. I mean, Mark MacDonald already explained why he was going to go overseas for experts, as it is Dr. Shuley has assisted in this process. But it should be noted that no credible UK expert has offered explicit support for the prosecution case. So there is no one. In fact, not only UK expert, no expert, full stop. The point is not made out of a lack of respect for experts working outside the UK. However, it is at least plausible that experts primarily working in North America and Asia would have a different perspective on clinical notes created by doctors and nurses working with the NHS than those who primarily worked in the UK. So I didn't make this point, but this has just occurred to me. Dr. Evans is not working in any hospital, let alone in the UK. He hasn't worked in hospital for 17 years. So he was the primary instigator of these theories. So the idea that he's got a superior perspective on these world experts who happen to live in a different country is just staggeringly ridiculous to even suggest that. However, I have written, the human anatomy remains the human anatomy regardless of what country you're located in. Otherwise, if you became ill on holiday while overseas, it wouldn't be possible for doctors to treat you. I think even the lawyers themselves don't really buy into this argument. There is an air of desperation in the assertion that this is plausible. Healthcare practices are standardised across various countries, and all manner of effort is made to harmonise this. As an example, European standards are established for medical devices. It is a flight of fancy to suggest that a renowned expert working overseas won't understand our noble British ways. I might remind the lawyers that the British healthcare system is almost universally regarded to be disappearing down the toilet at a rate of knots. This was reflected in the assertion of Dr. Lee that the Countess of Chester would be closed down if it was operative in Canada. I'm sure that came as no surprise to anyone that has dealt with the NHS recently. Somehow, oddly, both this and the actual state of the Countess of Chester seems to have completely evaded your attention. What a strange oversight. The idea that you need British experts to assess the British healthcare system is jingoistic to the point of being practically Thatcherite. Apologies for anyone who likes Thatcher, but I just went on a bit of flight of fancy myself there with some language. But I think it is. It is. I mean, they're saying it's not made out of a lack of respect. I mean, it is. Firstly, it is lacking in respect, and secondly, it's not plausible. It's not plausible that experts primarily working in North America and Asia, who are absolute world experts, are less well placed to look at clinical notes in Britain than someone who hasn't worked in a hospital for 17 years. It's pure horseshit. It's absolute bullshit. So, I mean, that point is just laughable. The inquiry will note that all the professionals giving evidence before the inquiry were unanimous in saying that the blood results for child F were indicative of exogenous insulin. I'm not going to reproduce this whole passage, but suffice to say the lawyers have completely misunderstood this aspect of the application. They would need to let us know whether this was deliberate or accidental. It is also notable that Letby's defence team do not appear to have disputed that child F has been deliberately given exogenous insulin. And I've written, which is relevant because the point is that our experts who dispute this and who say, and of course they're experts that, again, far outrank those that appeared in court, that say that what has occurred in court with regard to this is farcical. And I've mentioned that I'm writing a book. I've interviewed many experts. I've cited various others. I'm actually meeting a professor next month, and all of these individuals have said, look, the results and what has been presented in court in relation to insulin is just completely wrong, and there's no way someone should go to prison based on this evidence. So I think nitpicking about, Letby's defence team accepted there was exogenous insulin is just, again, it's a nonsense argument. It's meaningless. I should also mention that it's been specifically referenced in one of the press conferences where, Mark MacDonald explained that Lucy accepting this, having been told, she was told someone's definitely been poisoned with insulin, and her acceptance of this, he made an analogy about the post office inquiry, which I thought was reasonable. It's not the point is that it's not established meaningfully that exogenous insulin was used. The fact that Letby's defence team didn't dispute this and the fact that people said this in court is, again, meaningless. So move on to the next bit. So in relation to child A, for example, the panel identify a blood clotting disorder suffered by mother A and rely upon that as evidence in support of the suggestion that child A was prone to develop blood clots. This ignores the evidence given at trial by Professor Sally Kinsey, haematologist at Great Ormond Street Hospital, that she had reviewed blood samples taken from child A during his life and confirmed that he had not inherited his mother's clotting disorder. This error arises from the absence of experts in haematology from the panel and from an apparent failure to review or consider the evidence given at trial. Now, I've written here the panel will be aware of this, and I'm quite certain that they are, because I'm aware of this and I understand why this statement is flawed. The evidence of Professor Sally Kinsey was poorly founded, and there are explanations related to antiphospholipid syndrome. This is the syndrome that they don't reference by name here. And its testing, which indicate very strongly, I would suggest that they prove this beyond doubt, that the evidence she gave during the trial was erroneous and should thus be discounted. Of course, the jury cannot know this. I'll just briefly mention as well that this document's making multiple references to child A and child B, despite the fact that these lawyers are not representing their parents. But I just want to discuss the Kinsey evidence in more depth briefly. So I just want to show briefly, with regard to this condition of antiphospholipid syndrome, that the assertions of Professor Kinsey in court were based on one blood test, but it's known, as is stated here, if you only have one positive test and it becomes negative 12 weeks later, you probably don't have APS. These two tests are absolutely critical. If you don't have these two tests, then you can't rule it out as well. So for her to categorically rule out antiphospholipid syndrome based on the evidence she had is something that she simply cannot do. So essentially, the evidence that was provided to the court was fundamentally flawed. This is known to be the case. This has been pointed out to be by several medics. So it certainly wasn't something that I knew. I'm not going to sit here and pretend that I understood this. I had never heard of antiphospholipid syndrome until quite recently. I don't have any medical qualifications, but it's something that I've researched. So now we're going to return to ChatGPT and ask ChatGPT a question. Do you need two blood tests 12 weeks apart to confirm or rule out antiphospholipid syndrome? Yes, to confirm a diagnosis of antiphospholipid syndrome, you typically need two positive blood tests at least 12 weeks apart. These tests check for antiphospholipid antibodies, which include, I won't continue any further, it gets quite complicated. Obviously, I wouldn't expect the lawyers at the Thirlwall Inquiry to know this. I'm sure they don't know this. And this could be one of the arguments they put into this document that they genuinely believe to be reasonable. Unfortunately, they don't really understand the case and they've overlooked this. And I only know about this because I spoke to people who know a lot more than me. So I think it's it's important to understand all the context and all the medical information that occurred within the court case, and not just cite things and say this definitively proves. I mean, it's far easier to understand the diagnostic information with relation to air embolism. It's pretty easy to understand that just because there's air present in certain vessels, it doesn't mean that it was injected in a harmful way, deliberately, maliciously. This is a bit tricky to understand, but I don't think it's that hard. Just simply the blood tests that have been done cannot confirm the presence or otherwise of this syndrome, and numerous medical professionals that I've spoken with have cited antiphospholipid syndrome. This is before the panel got together. Now the panel has got together and they've cited it as well, and the people that looked at these cases have cited it as being significant. So while the lawyers may genuinely believe that what they've presented there is legitimate, unfortunately when you look at the evidence, it doesn't really stand up to scrutiny. So I'll just move on to the next part of this document now. It's another argument that's exactly the same as the previous one. Child A had not inherited his mother's clotting disorder was accepted by the defence at trial. And I've just again said which is relevant because it's not relevant. We're not at trial now. Just because the defence said this at the time, we now have world-class experts who say something different. So, and their views have to be taken seriously, clearly. The panel also ignored the evidence from Dr. Manarides and Professor Arthurs in relation to Child A, as it did with Child O. We've already addressed that, by the way. That the evidence showed that in life, baby air had air bubbles in his brain and lungs immediately after his death. A lot of air was found in his great vessels. As I said here, firstly, they didn't ignore this, they didn't consider it to be irrelevant. Secondly, the presence of air is not proof of air embolism, as we've already discussed. It can occur accidentally and almost always does. Air is present in many infants without it being firstly deliberately injected, and secondly, the infant suffering any illness from this, let alone a life-threatening collapse. There are very few cases of fatal air embolism. This is conceded by both Dr. Evans and Dr. Bohin, and is one of the central contentions of Dr. Lee. In fact, injecting air into an infant is an extremely inefficient way of killing them, not least because it probably will not. Furthermore, there are serious doubts whether it was even logistically possible to administer the quantity of air seen in the infants this way with equipment available at the counters of Chester. So just to explain this briefly, the kind of size of syringe that has been cited, I mean, most people I've spoken with say that it's just logistically impossible, let alone logistically feasible. Regardless of this, the presence of air does not prove air embolism. It simply does not. This is why it has been discounted by the panel, not because they're not aware of it, but because it's not remotely relevant. So here we are back with ChatGPT again, just to demonstrate this. So I've asked this question: does the presence of air in an infant in either the great vessels or other parts of its body indicate that air has been injected deliberately? The presence of air in an infant's great vessels, such as the heart or major arteries, veins, or other parts of the body, does not necessarily indicate deliberate injection. Air embolism can occur due to various natural and iatrogenic medical intervention-related causes, including resuscitation, decomposition, trauma, obstetric causes, medical procedures. So, again, it's just to come back to what we said earlier, it's consistent with, but it's not diagnostic of this at all. So to return to the document, the next comment made is the panel include within their general findings that poor plumbing and drainage resulting in need for intensive cleaning. This was a potential factor in Strenotrophomonas maltophilia colonisation and infection. The inquiry has heard evidence about potential concerns at the COCH regarding infection passing from the plumbing, and that this was considered at the time and excluded as a potential source of harm to the babies. Well, it wasn't excluded. The defence called evidence from a hospital plumber at trial who referred to certain plumbing problems that occurred in the unit, but crucially none that occurred at or about the time of any incidents referred to within the indictment. This statement therefore appears to be ignorant of the issues raised at trial, presumably due to the fact that the experts on the panel were unaware of the evidence given at trial. Well, I think that's highly unlikely. I'm sure that they're very much aware of the evidence given at trial, seeing as it's publicly available. I've seen virtually all the court transcripts and all court reporting for all the days where transcripts are not available. So I find it very unlikely that they're not aware of evidence given at the trial. However, I've said here, this is a rather pathetic argument. I'm 100% certain that Mark MacDonald is aware that a plumber was called. I believe he has mentioned this when interviewed. I'm also certain that the panel will be aware of this. Their argument is simply that this was not communicated to the court acceptably, that the significance of condition at the hospital were not satisfactorily accounted for, and this was therefore never explained to the members of the jury, who cannot possibly understand this as they are laypersons. It's not merely the sewage, of course. The sewage is instrumental in the development of sepsis, and we now know that 9 of the 17 infants in the court case had either confirmed or suspected sepsis. This document doesn't reference sepsis whatsoever. It just speaks about the sewage, but the sewage is part of a broader argument that is not presented here. The families are concerned that the panel appear to be describing issues that have already been ventilated at trial or which were considered as part of the first appeal. I mean, this is simply incorrect, even having seen a small proportion of the overall evidence. At the highest, the panel put forward alternative explanations for why some but not all of the babies collapsed and or died based upon a review of the medical records, and some but by no means all the evidence called at trial. This is just a stupid statement again. I've just said I'm pretty sure the final reports will include explanations for all infants. This is simply a nonsense argument. The evidence called at trial is not relevant to the medical opinion, as already discussed. It is difficult to see how a panel of experts for a single discipline provided with limited evidence could reach a better conclusion than experts of multiple disciplines considering the evidence in the round. I mean, this is very indicative of the fact that this is a lawyer's statement, because no normal human being would use this expression. This is a lawyer expression, evidence in the round. I had to look it up just to make sure. It's pretty clear what it means, but I had to look it up just to make sure that I had understood it correctly. It just means holistically, essentially. So this is just more repetition. We've already dealt with this earlier in the video, so there's no point going over it again. It is unclear to the families why Mr. MacDonald, or his instructing solicitors if he has them, would instruct multiple experts for a single discipline to undertake a limited review of the evidence and present their findings as superior to the evidence adduced at trial. I've already addressed this as well. I mean, this is just a repetition anyway. The elephant in the room, which Letby's legal team appeared to be studiously ignoring, is that Letby had experts available to her at trial. These experts were not available at the trial. I'm also not aware that she had more than one expert, which I deal with later in this, in this document, who had access to all the same material available to the prosecution experts and who provided multiple reports. That is, and I've written, that is only the elephant in the room to lawyers who wish to elevate the process in court to something of biblical significance. What matters is what happened in actual reality in the hospital, which is, of course, exactly what these neonatal and paediatric experts have assessed. And they've done it, obviously, in a more holistic and far more thorough way, with far more qualifications than the panel. They didn't have a panel in court. It was basically just Dr. Evans. The families would also observe that it is easy to make points at a press conference and somewhat more difficult to do so at a trial, where the evidence being given is scrutinised and tested. So I said, yes, we saw that with Dr. Evans, who said stuff like this. What's the evidence, Myers asked him. Baby collapsed, died, Evans responded. It really sickens me to read this out, by the way. A baby may collapse for any number of reasons, Myers said. What's the evidence that supports your assertion made today that it's because of air going down the nasogastric tube, NGT here? The baby collapsed and died. Do you rely upon one image of that, Myers asked, referring to x-rays? This baby collapsed and died. What evidence is there that you can point to? A baby collapsing and where resuscitation was unsuccessful, you know, that's consistent with my interpretation of what happened. And then I've written, you don't seem to be quite so critical of the prosecution case for some reason, Mr. Simon Driver, who coincidentally worked for the prosecution, but it's not a conflict of interest, of course. One might suppose the expert witnesses relied upon by Letby at trial would have managed to give a cogent and convincing account of their opinions at a press conference in the unlikely event that they've been asked to attend one. And I've said, you obviously haven't encountered Dr. Evans. He has yet to give an explanation of anything that is cogent, let alone convincing. Why then didn't Letby call them to give evidence at trial? The families will say that she is refusing to disclose this for one. This is such nonsense. It really is. The families will say that she is refusing to disclose this for one obvious reason. She understood that as clear as her experts were in their written reports. When faced with the full evidence or when questioned by the prosecution, they would have effectively convicted her. So Lucy Letby, while incarcerated because she was denied bail, read through reports submitted by Professor Michael Hall. As an aside, this document continually references experts working for Letby. I've never seen any previous evidence that there was more than one. And despite having been in prison for 2 years, despite not having any medical training, she was able to deduce from reading those reports that a court and jury, when faced with this medical evidence, would be able to see through it and convict her, and so it would be to her advantage not to have any medical experts in the court case, so she instructed her lawyer against his better judgment to remove them from the court process. I mean, it's absolutely ludicrous, obviously. So I've written here, in other news, a squadron of pigs was seen flying over the Bermuda Triangle, but they were shot down by Elvis and Lord Lucan. I mean, it is a ridiculous assertion that just has absolutely no merit whatsoever. The next section then states the key deception in Letby's approach in holding press conference. I mean, this is like, it's just unbelievable. I mean, lawyers really do get money for old rope. They really do. It's unbelievable. They just have to sit there for hours concocting this absolute rubbish. The key deception in Letby's approach in holding press conferences is that she can present evidence without the risk that it will be analysed, challenged or questioned. It permits her to control the narrative without having to explain. Let's just remind ourselves, Lucy Letby's in solitary confinement. She's not even allowed to speak to anyone else, barely. She's just locked away in a cell on her own with very little access to anything. Let's just let that sink in for a second. It permits her to control the narrative without having to explain why she chose not to call that evidence at trial. It'd be pretty difficult because she's not allowed to speak to anyone. It is not new evidence, but rather a rehash of evidence that was available to her at trial and which could have been called in her defence had she been willing to subject that evidence to scrutiny. I mean, what complete crap. What absolute crap. I mean, it's just utter nonsense. So I've written that this is drivel. It is now suggested that Lucy Letby has removed evidence from the court case so that she could put evidence that didn't yet exist into an appeal from a panel that had yet to be assembled, which was assembled by someone that she didn't know existed, who was instructed by someone she had never met before, and that she knew if she did this, then it could be presented without challenge, which wouldn't be the case in court. I should add to that as well, it's involving medical information that she knows nothing about and wasn't aware of before it was put into these reports. I mean, it is utter nonsense. They get paid tons of money. They get paid tons of money to come up with this crap. It's unbelievable. It's unbelievable. I mean, I'd never be proud to call myself a lawyer. I would be ashamed. Truly. I mean, there's some good lawyers who do human rights stuff. You know, I've spoken to one, I've interviewed one, so, credit to them. But, I mean, overall, I just find it such a dismal, kind of grimy profession. You know, I'm sorry to say that. I don't get any pleasure from saying that, but, they literally have to just concoct these arguments that they can't possibly believe in. They can't possibly believe that is a reasonable argument. An 8-year-old would be able to see through that. I mean, it's just ridiculous. You know, the idea that she's orchestrating this incredibly complex, literally logistically impossible act while in solitary confinement is she in HMP Bronzewell? In solitary confinement as a Category A prisoner, with, having been broken down mentally and psychologically, not having any medical qualifications, not having access to, I mean, come on, it's just embarrassing. It's difficult to see how the Court of Appeal could reach a different position with regard to the new evidence adduced by the international panel. It should be said with regard to this that lawyers have disregarded most of the new evidence in this statement. In fact, they've mentioned only one of 11 points. Altering the text of his original study, as Professor Lee did prior to the press conference in February 2025, to provide greater clarity as to what that study meant, does not amount to fresh evidence any more than the clarity that he sought to offer when giving evidence to the Court of Appeal in 2024. In any event, as the Court of Appeal observed above, the clarification of that evidence does not overcome the insurmountable hurdle described by the Court of Appeal in the extract above, and therefore does not progress the issue further. So firstly, this is a misrepresentation of what has occurred. I should mention again, there are 11 items of new evidence and this is only one of them. However, it is worrying that this document is now relying on procedural arguments rather than a sincere belief that Lucy Letby is guilty. It is not contested that Dr. Lee's paper was instrumental in the court case. It is also not contested that Dr. Lee has dismissed the prosecution case. It is therefore quite feasible that Lucy Letby has been convicted on erroneous evidence. It is therefore completely wrong to keep her incarcerated simply because it can be legally justified. This was, in fact, argued by Sir David Davis in Parliament. It is incumbent on the system, particularly for a case of this magnitude, to ensure that actual justice is done and that the verdict of the criminal justice system is one that reflects reality rather than relying on arguments of jurisprudence. And it's critical to note that The evidence that was relied on in court that was diagnostic about the discoloration is simply wrong. And it was this paper of Dr. Lee, as can be demonstrated very clearly from public statements and statements that were made in court, was instrumental to that diagnosis. Dr. Lee has now said, well, that's all completely wrong. It's a fundamental mistake in medicine. They've misused my paper. Here's why they've done it. Here's another paper explaining more about this issue, etc., etc. It's gone through a diagnostic. It's a study of all the known cases. And he's just simply said the discoloration that has occurred in these infants just hasn't been observed anywhere else, and it's not diagnostic of air embolism. It's the one diagnostic criterion of any merit whatsoever. So to kind of hand wave this and say, oh, procedurally though we can keep her in prison, is pretty low in my opinion. The families would also observe that in providing evidence based upon medical records that were available to Letby's defence experts at trial, which isn't true, the panel also do not provide fresh evidence. A defendant is not entitled to refuse to call evidence at trial that would harm her defence, only to thereafter produce evidence from different experts addressing the same issues and claim a right to retrial in the hope that they may do better next time around. Insofar as the evidence from the international panel seeks to raise new arguments, it is firstly not clear that these are in fact new arguments, with many or most of the same issues having been examined at trial. As I say, they've only mentioned one of the 11 arguments here. This is another procedural argument and does not provide any support for the notion that the lawyers genuinely believe Lucy Letby to be guilty. The document goes on to state, secondly, there are obvious deficiencies in the disclosure of material to the experts, methodology and breadth of expertise that would inevitably undermine the evidence if it were presented at trial. This is pure speculation. However, it seems likely that the complete opposite is the case. It is acknowledged and will be recognised in court that the panel experts far outrank those involved in the prosecution case. Indeed, I have little doubt that they would have performed much better in court. And I think anyone that's seen Dr. Evans be interviewed or read any of his comments from the court transcripts would agree with that verdict. This is pretty much the universal opinion of anyone that has studied this case who isn't affiliated with the prosecution. I'll come on to addressing this further in a second. I just want to get through these paragraphs. The jury were entitled to consider whether there were alternative explanations for the deaths and collapses. Indeed, various alternatives were postulated at trial. Having heard all the evidence, they concluded that Letby was guilty of murder and attempted murder beyond all reasonable doubt. As I've said, virtually none of the information presented by this panel was available in court, nor was it communicated to the jury, so this is another utterly disingenuous statement. It is fanciful to suggest that this evidence would have caused them to reach a different conclusion, and I've said this is simply a stupid statement that is completely without foundation. So I must mention at this point that the critical thing really is that the medical evidence that was presented in favour of the prosecution case was fatally flawed, and that's being generous. And this wasn't properly examined during the court case. Had it been examined by the 14 absolutely world-class neonatologist paediatric experts, I've gone through half of them in this video, there is no doubt that the prosecution would have been absolutely clobbered by these experts. I mean, Dr. Evans was pretty strongly challenged at times by Ben Myers anyway. And since the court case, his diagnoses and opinion has fallen apart further still. So this all focuses on kind of nitpicking technical procedural arguments that really have no merit whatsoever. What is actually important is that 14 experts have conducted an actual scientific process which didn't occur in the prosecution case, and they've concluded that there were no murders at this hospital. The only way to really challenge that, given the poor standard of the prosecution case, is to try and nitpick and use kind of procedural jurisprudent arguments that lawyers love to use. Ultimately, and I mean this thing at the end is fanciful to suggest this evidence would have caused them to reach a different conclusion. Once you have the very small number of experts that favoured the prosecution, that appeared in court for the prosecution and provided some extremely unlikely diagnoses, and then they're up against these world-class experts who would just destroy them, demolish them over and over and over again. To say that it wouldn't cause the jury to reach a different conclusion and to say that this with any kind of certainty is just utterly ridiculous. I think the lawyers know that this is a statement that is completely without foundation, as I have suggested. And I'm going to come on to the kind of conclusion of this document now, which kind of focuses on what has occurred today regarding the pausing of the inquiry. So I'll go through this section as quickly as I can because we now know the inquiry hasn't been paused, which was quite predictable. The families will say that there is no obvious benefit to stopping the inquiry now, indeed there are clear and overwhelming disadvantages. So I've written, it would seem ensuring that the inquiry doesn't reach very poorly founded conclusions, having never examined critical evidence, which then pollutes the entire British healthcare system, would be a fairly compelling advantage. The purpose of the inquiry is never sought to address whether Letby murdered or harmed babies on the neonatal unit between June 2015 and June 2016, but rather to examine the response of the Council of Chester to that event. And I said in response, no one has ever claimed that it did, but because it made this assumption, the inquiry has done a palpably poor job of examining circumstances at the hospital, which therefore means that its conclusions are erroneous. I have already explained the consequences of this in the previous comment. The inquiry's findings with regard to that response have broad application to the numerous patient safety issues across the breadth of the NHS. Yes, correct, that's why it should be paused, Einstein. The importance of this inquiry goes beyond preventing the next healthcare serial killer. So I've written here, it's nice to know that you've concluded that there will definitely be another healthcare serial killer, not that you've come to this with a jaundiced perspective, of course. It will provide benefits to patients in numerous scenarios. It won't provide benefits if the recommendations are based on erroneous information, quite the opposite. It should, the families hope, lead to a more open, honest and transparent culture within the NHS. It's hard to see how this more open, honest and transparent culture will result from the systematic repression and denial of important information. It should, they hope, lead to a safer NHS. Let me reiterate, it won't lead to a safer NHS if the inquiry is fundamentally flawed. One of the major consequences of this is that many nurses already fear for their safety. There has been a notable migration of nurses out of the profession. It would be very difficult for me personally to recommend anyone that I know to go into nursing at this time, and I already know people who have abandoned their nursing ambitions because of what has happened to Lucy Letby. This will only get much worse if stringent recommendations are published based on this flawed inquiry. Considering that the NHS is already deeply in a massive crisis, it's hard to imagine that this could result in anything other than a less safe NHS. The approach by the executives to halt this inquiry, and indeed by Letby, we're not Letby supporters, we've already established this, to do the same thing is, insofar as the families are concerned, a naked attempt to prevent the inquiry from reaching conclusions that criticise the actions of the executives. So in response to that, I've said, this is an assertion that is completely without foundation. According to previous comments in this document, the efforts to stop this inquiry have all miraculously and in some unspecified manner emanated from Letby herself. Why would she care about executives at the hospital being criticised? Furthermore, I think it is incredibly difficult for this group of lawyers to assert that other groups are guilty of bias without skating on some particularly thin ice. From Letby's perspective, she's keen to control the narrative. I mean, this is just some bullshit that they keep repeating, and prevent the events that occurred being set out in a way that she cannot control. I mean, what absolute crap. I'm confused. I thought this was a naked attempt to prevent the inquiry from reaching conclusions that criticise the actions of the executives. Little did I know that Puppet Master Letby was behind the whole thing. It is, as the inquiry occurred following June 2016, an attempt by Letby to use her own victimhood as a way of deflecting attention away from her actions. This is an appeal to emotion and yet again utter drivel. None of these motivations are reasonable or credible reasons for stopping now. This is a classic example of a straw man argument in which an argument is deliberately distorted and misrepresented. The motivations described here are not the real motivations for opposing the inquiry. As an example, Sir David Davis has written to the inquiry, and it's pretty difficult to argue that he was manipulated by Lucy Letby considering that he has never met her. Davis is no doubt, as he has indeed explicitly expressed in his letter, concerned that the inquiry is completely unrepresentative of what actually occurred at the hospital and will ultimately produce recommendations that are dangerous for the healthcare system as a whole, something that does affect him in his profession, which doesn't affect any of the lawyers in the slightest. Of course, this argument is an entirely legitimate one for pausing the inquiry. Thankfully, some good has come out of the process, as we are now aware of an avalanche of information which completely contradicts everything that's been conducted publicly at Thirlwall. The lawyers that are representing the families appear to be blissfully unaware of this. It cannot be stated strongly enough that if Thirlwall continues and then recommendations are made based on the public process of the inquiry, this would be calamitous and hugely dangerous for healthcare in Britain. I would suggest that it would threaten the entire existence of the NHS, considering the beleaguered state it finds itself in already. And I want to come on to this last paragraph, and I'm going to go into this in more depth, but I will finally mention that in this statement on behalf of families, there hasn't been a single reference to the fact that the way the health of infants was portrayed in court has been roundly criticised, including by the panel. I believe it is absolutely incumbent on lawyers representing these families to communicate this to them, as otherwise they are likely to have a misguided impression of the clinical circumstances surrounding their children. I think to do otherwise is an absolute dereliction of duty, and it should be considered extremely concerning that there is simply no reference whatsoever to the fact that numerous medics, not merely the expert panel referenced, have seriously questioned the way that the clinical condition of these infants was portrayed in court. So I'm going to briefly go on to this matter and discuss some of these issues as quickly as I can and some related issues before concluding the video. So I just want to finally discuss the picture related to these infants. I've put this together very quickly, basically from memory. So it doesn't deal with all the infants in the case, and it certainly doesn't deal with all the problems, issues and health conditions. But just to briefly mention, child A, as we've just mentioned, linked with antiphospholipid syndrome, seems very likely they were suffering with that. Child with suspected sepsis, it's a twin, so that instantly makes the child more vulnerable. And there were repeated failed catheterizations on the unit, which also amplifies any existing health conditions. Child B, another twin of child A, antiphospholipid syndrome again, strong evidence of infection, breathing and respiratory issues from birth. In the case of child C, there's sepsis present. This is a very preterm baby, as indeed basically every other infant in the case is, or the ones we're going to discuss here. This required respiratory support from birth, weighed less than 2 pounds, was described by, I believe, staff on the unit as the tiniest baby that they'd ever seen, and had a catalogue of health issues. Child D, sepsis, chronic pneumonia. It was floppy within 12 minutes of birth, another very preterm baby who required constant respiratory support. Child E, another case of sepsis, very preterm baby, very low birth weight, massive respiratory issues, problems with oxygen, and there's overwhelming evidence of bowel obstruction in this infant as well. Child F had sepsis, blood glucose issues, just mentioned briefly the bag that supposedly spiked while Letby was absent, and this is another preterm baby. Child G had sepsis, less than 50% chance of survival due to its extreme prematurity, weighed just 535 grams at birth, experienced continual desaturations, another one who had an absolute catalogue of serious ailments. I missed out Child H because Letby was found not guilty. Child I, sepsis, extreme prematurity, necrotizing enterocolitis, weighed under 1 kilogram at birth, multiple deteriorations. Missed out Child J because Letby was found not guilty. Child K already had a less than 50% chance of survival at birth. And I haven't gone into all the issues regarding this because this is the most ridiculous case that this should never have resulted in a prosecution. It's just absolutely ridiculous, really obvious accidental tube extubation, removal of a tube. It didn't pass away in the Countess of Chester Hospital. It passed away, I believe, in Arrow Park Hospital 3 days later. Letby wasn't even involved with this infant. She probably wasn't in the room at the time. There's no medical evidence whatsoever, but it was an extremely vulnerable infant, and it was statistically probable that it wouldn't survive. Child L had anomalies in insulin resulted that were solved by a sticky insulin theory, and also issues related to hyperglycemia. So there's a list of health conditions that can be listed, that can be linked with the infants variously here, and that this is not exhaustive. There are other conditions, there are other problems, there are other issues, but it includes pneumonia, sepsis, lactose intolerance, Pseudomonas infection, acute lung injury, respiratory distress, necrotizing enterocolitis, antiphospholipid syndrome, livedo reticularis, placental deficiency, trauma from failed catheter insertion, thromboembolism, apnea, rupture of membranes, respiratory acidosis, increased coagulation time, intrauterine growth restriction, respiratory distress syndrome, chronic lung disease, bradycardia, repeated desaturation, and strenotrophomonas multifilia infection. Apologies for that pronunciation. And of course, they're virtually all premature. They're all premature. Some of them are extremely premature, low birth weight, and they're all intrinsically vulnerable. And then on top of that, you have the fact that bacteria is known to be circulating on the unit. All the swipe card data that was used in court is incorrect. We know it's incorrect for 9 doors. Then there's the problem with stairs into the nurseries that has been documented in The Guardian, which someone who worked at the hospital told me that you could walk into the main nursery, go through this door that doesn't even have a swipe card. 5 o'clock comes round, you finish your shift, you walk out the door, go down the staircase, walk across the road, you're in the pub, over the road, and the system is still showing that you're in the nursery. So the swipe, that's before the fact that the reverse evidence related to 9 infants in the case. Then there's the third insulin case that's come up recently that has been reported on in an Unheard article by David Rose, aforementioned David Rose and Closey de Oliveira, which calls into question seriously the other insulin cases, even on top of the other evidence related to them. Then you have the fact that Letby is not on duty for many of the collapses that I discussed earlier in the video. Then you have the fact that there are 11 other infants that died on the unit that are not included in the case. And I'm sure there were countless other infants who had collapses. Indeed, there were countless other collapses not included in the case, even for the infants that were included. And many of these occurred at other hospitals. They didn't even occur at the Countess of Chester, because 11 infants were transferred out to other hospitals due to various inadequacies at the Countess of Chester. Indeed, there were a catalogue of issues related to very poor medical care, which resulted in the unit being quite rightly downgraded. That's just a very brief synopsis that I put together in a matter of a few minutes, because I really haven't got time to do it justice properly. But you can see across all these issues and across all these infants, there are major problems. Now, my question would be, has this been properly communicated to the parents by the lawyers that are representing these parents? It seems to me that it hasn't been properly communicated, firstly probably due to a lack of understanding, and secondly due to the fact that none of these things are even remotely mentioned in the document that we've just encountered. So I would consider that to be a dereliction of duty, and I think it's absolutely critical for these parents to know that there were major mistakes made at this hospital. These were extremely poorly infants that were vulnerable anyway. Some of them would have been expected, sadly, to pass away just on the basis of probability. And others, if they're not being cared for at a competent unit with good sanitary conditions, they're already vulnerable and they become very vulnerable very quickly, which is quite rightly why this unit was downgraded. So I haven't really prepared a conclusion for this video, except to say that I hope it's been informative. I did feel that the comments of the lawyers needed to be countered, because while they appear to be superficially convincing, they're actually very much flawed and in some cases unfounded. I think there's some very specious arguments in there, a few legitimate ones that I've obviously acknowledged where they occur, but there are very clear counter arguments to virtually everything that's presented. It didn't really take me a great deal of time to put the document together, and it hasn't taken me an enormous amount of time to make this video, except that I am not a video maker and that posed some technical issues. So I suppose the last thing I'd like to say, the last couple of things, is firstly, thank you to everyone that's taken the time to view. I'd like to apologise that I'm a writer, I'm not a video maker, I don't have any skills. I'm sorry this hasn't been in any way interesting to look at. I apologise if the quality of the video is not very good. It was the best I could do. It needed to be done quickly by someone that is not, unlike the neonatologists on this panel, I'm not a world-class video maker, so I did the best that I could. And then just the last thing I'd like to say really is, if you have any comments, queries, questions, observations, corrections, etc., please do comment. I'll try to respond if I can. And thank you for your interest.